committee. And we just want to wish you the best, and we'll let you go at this time.
Thank you very much, Mr. Chairman.
Thank you, Dr. Greenspan. Our next witness is Dr. Janet L. Yellen, Chair of the Council of Economic Advisors. Dr. Yellen, thank you for coming this morning. We appreciate you being with us to share with the committee your insights on what we consider to be a very timely subject. So we'll turn the time over to you.
Thank you, Mr. Chairman. It's a pleasure to be here, members of the committee. I'd like to talk this morning about some of the economic issues raised by the current merger wave, and I understand that my written testimony will be entered into the record.
Without objection.
So I'll try to be relatively brief in my remarks. Given the attention merger activity is receiving, one's naturally inclined to ask whether we're in the midst of an unprecedented merger boom. My written testimony shows that the United States has, in fact, gone through 4 previous merger waves in the past 100 years. By almost any quantitative measure, the current merger wave is substantial. For example, Exhibit 1 in my testimony provides a sample of recent mergers. The value of all deals announced in 1997, $957 billion, was equivalent to about 12% of GDP. And activity so far in 1998 suggests another record year by this measure. The last time that merger activity was this large as a share of GDP was during the great merger wave at the turn of the last century. But one reason current merger activity is so large relative to the size of the economy is the run-up in stock prices in the past few years. When merger activity is expressed relative to the market value of U.S. companies, its level remains lower than it was in the 1980s, that you can see in Exhibit 2 in the lower panel. Right. However, based on the volume of merger activity so far this year, 1998 is likely to show a substantial rise over 1997 in this measure of merger activity as well. What does this merger activity mean for the economy? I think it's fair to say that economists have found little reason to believe that the broad economic indicators, like the rate of economic growth, inflation, or unemployment, are much affected by changes in merger activity or the share of aggregate economic activity that is accounted for by, say, the largest 100 or 200 firms, at least on the order of those that have typically been observed in the United States. Economic analysis suggests that the main route by which mergers affect economic performance is through their impact on competitive conditions in specific markets. Recognizing this, it might not be surprising that we found no comprehensive recent research on trends in aggregate concentration. As shown in Exhibit 4, however, the share of the total assets of non-financial corporations held by large firms fell over the course of the 1980s, and aggregate concentration in manufacturing fell slightly in the early 1990s. On the question of whether individual U.S. markets are, on average, becoming more competitive or more concentrated, we also found no reliable comprehensive study. And this is mainly because of the care and the effort that is needed to define the relevant market in every particular case. Because appropriately defined markets may not be national in scope, and they may not correspond to standard industry definitions, readily available data may not be terribly relevant for public policy purposes and should be interpreted with considerable caution. Mr. Chairman, large firms and the merger of large firms are an important feature of the American economy, but they have been for over a century, and there's little evidence of any alarming trend toward greater concentration of economic power in the aggregate. The analysis of how mergers affect economic performance should therefore focus on the impact of mergers on specific, well-defined markets. Keeping that perspective in mind, let me now turn to the causes and consequences of mergers. The main reason managers give for undertaking mergers is to increase efficiency. And studies show that on average, the combined equity value of the acquired company and the purchasing company rises typically as a result of the merger. However, an increase in shareholder value can arise for reasons other than greater efficiency, such as increased market power and the resulting ability to increase profits by raising prices. And the separation of ownership from control in the modern corporation means that mergers may serve the interests of managers more than shareholders. Finally, even if mergers are designed to enhance efficiency, they often don't work and can instead create inefficiencies. Some, for example, see the merger of Union Pacific and Southern Pacific Railroads in 1995 as a notable example of such an outcome. There are numerous ways in which mergers can contribute to economic efficiency. One is by reducing excess capacity, and that justification has been invoked in hospital, defense, and some banking mergers. Another is by achieving economies of scale or network externalities. The hub-and-spoke system that emerged following deregulation of the airline industry is an example, although that's one that raises questions of increased concentration as well. Or there can be efficiencies through economies of scope or synergy, as in the case of investment in commercial banking, where similar risk management techniques and credit evaluation skills may be utilized in a wide variety of financial services. And mergers may improve management. For example, studies suggest that there are large differences in efficiency among seemingly similar firms like banks. Most mergers probably are undertaken with the expectation of achieving efficiencies, though the outcomes may sometimes be disappointing, and so divorces are not uncommon, such as the unraveling of AT&T's 1991 acquisition of NCR. And studies of bank mergers suggest that in spite of the potential for improved efficiency, in general, they have not improved the efficiency or profitability of banks. Mergers can be undertaken also to increase market power and concentration. And in that event, consumers could be harmed through higher prices, lower service, reduced variety, and, in the view of some, a reduced pace of innovation, although some argue that increased market power should instead raise innovation due to the increased ability to appropriate the benefits of R&D. Mergers can also work to decrease the potential for future competition. There is abundant evidence that when one compares markets of a given type, for example, local banking markets, the degree of concentration in a market is correlated with such measures of economic performance as prices and profits. And there's some evidence that mergers have raised prices, as in the case of the mid-1980s airline mergers. Other things equal, higher concentration leads to worsened performance, which is why the merger guidelines, after assessing what the appropriate definition of the market is from a geographic and product perspective, looks at the impact of a merger on the level of concentration. But statistical evidence suggests that this, namely increasing market power, is not the main motive for most mergers, and perhaps that reflects the presence of antitrust monitoring and enforcement. Thus far, I've been discussing motives for mergers generally, and a natural question is why we're seeing so many firms merge now. I think there's no single reason, and I would just offer some of the prevailing explanations. One explanation relates to regulatory barriers. Mergers have followed the removal of branching restrictions in banking and ownership restrictions in radio. The second reason relates to technological change. Innovation can change the size and type of firm that's seen as most profitable. For example, large scale may be needed to exploit some advances in information technology and telecommunications, such as credit scoring. Globalization is a third factor. The emergent global economy may demand large scale to participate. A European and American firm may combine to take advantage of the distribution networks that each has on its own continent. Also, to the extent that European or Asian firms are more integrated in certain sectors, like the financial sector, U.S. firms may find it necessary to integrate more to provide one-stop shopping for foreign customers who demand that. A final explanation relates to the high stock market. Price-earnings ratios have increased to near-record levels during the current merger wave, and some analysts feel that the market may be overvalued. Such high stock market values may make it seem attractive to fund an acquisition for stock, which is the dominant funding source in the current merger wave. But an overvalued stock market should not necessarily lead to more mergers, because if other firms are also overvalued, then there are fewer attractive targets to acquire. As I mentioned earlier, in evaluating the consequences of mergers, we should focus on particular, well-defined markets. And in that regard, it's important to recognize that mergers do not necessarily increase concentration in any well-defined market. Merging firms may be in different businesses, in non-competing regions, or in supplier-buyer relationships. In banking, for example, national concentration is increased dramatically due to mergers, but concentration measures for local banking deposits have been quite stable because most mergers have been between banks serving different regions. And even when the merger is among competitors, increasing global competition or domestic entry could be simultaneously reducing concentration. In addition, the entry of new firms or the threat of entry can offset the potentially anti-competitive effect of a merger. And finally, the structural characteristics of markets, and not just the number of firms, influence the nature of competition in a given market. So we cannot automatically conclude that a market with, say, 2 or 3 competitors is automatically less competitive than one with 20 or 30. To wrap up, the United States is currently in the midst of its 5th major merger wave in the past 100 years. Industries that are particularly prone to mergers include telecommunications, banking, financial services. And these are sectors in which the regulatory environment has been changing rapidly, opening up new opportunities and challenges. This merger wave is taking place in a strong stock market, and stock rather than cash is the preferred medium for making acquisitions. Many of the prominent mergers are neither purely horizontal, because in general horizontal mergers would raise antitrust issues, nor purely conglomerate. Rather, they represent market extension mergers where companies in the same industry that serve different and currently non-competing markets, or mergers seeking synergy among companies in different industries. Analysis of the economic impacts requires careful analysis of particular markets and hence defies easy generalizations.
Well, thank you so much. Let me just ask a few questions. As you note in your statement, the increasingly global nature of our economy and the need for U.S. firms to compete on a global marketplace is clearly one of the forces driving many of the recent mega mergers. Many also use the globalization trend as as an asserted justification for why these mergers should be approved. Now, let me just spend a minute or two taking a closer look at this issue, because there are actually, at least in my opinion, 2 distinctly different sets of strategic imperatives that might follow this so-called globalization trend, each, I think, having different consequences. On the one hand, it might be the case that U.S. firms are actually faced with competition here in domestic U.S. markets from foreign firms. That might be one of them. To the extent that this is the case, it seems to me that this form of competition ought to be considered in the analysis of a merger. On the other hand, it might be the case that U.S. firms are competing with foreign firms to capture emerging foreign markets, especially in third world countries. Where this is the case, global issues may indeed be relevant to the antitrust analysis, but it is still a different calculus. Now, which do you think is the predominant force with respect to globalization driving today's merger mania? Increased foreign competition in domestic markets, or pressure to compete with foreign firms in foreign markets?
Senator, I believe that in different cases, both forces might be relevant. It's hard to generalize. Certainly the second force of merging to compete abroad in foreign markets, I believe is relevant. It is the stated motive in a number of industries to achieve the kind of scale that may be necessary to serve foreign markets. But there are industries as well where foreign competition has been significant in the United States. Banking, for example, is an example of an industry where we've seen significant foreign competition placing pressures on firms in the United States. But even in that industry, the motives go beyond foreign competition.
Am I correct in assuming from the statement you just made that you believe that promoting U.S. industries' competitiveness in foreign markets should be an objective of merger enforcement policy?
Well, I think that the basic objective of merger enforcement policy should be, as the antitrust statutes indicate, to ensure vibrant competition to protect consumers in the American market. And so our antitrust statutes and merger reviews are oriented to ensuring that mergers will protect competition and ensure that consumers are not harmed by increases in market power.
I see. Do you have any concerns regarding the role of foreign governments in reviewing mergers between U.S. firms?
I think the area of cooperation with foreign antitrust officials is one that the Justice Department has paid increasing attention to. Certainly an increasing number of mergers, we saw this last year in the case of the Boeing McDonnell Douglas merger, can involve reviews by a number of different antitrust authorities in different countries, and I think this is an area where increased cooperation is important.
Well, in studying whether these mega mergers ultimately favor or injure consumers, it has become clear to me that there usually are countervailing forces that operate against one another, and so the trick is to understand which of these forces is likely to prevail. For example, one of the commonly cited reasons underlying most of the mega mergers over the past several months has been the opportunity to achieve greater efficiencies resulting from so-called economies of scale. And it is argued by some that these efficiencies will lead to lower operating costs and thus benefit consumers by lowering prices. At the same time, however, many, if not most, of these mergers lead to higher market concentration, which increases the market power of the merged firm and makes it more likely that the firm will keep efficiency gains in the form of higher profits, as opposed to passing on the savings to the consumers. Do you have any insights regarding when cost savings from a merger are likely to be passed on to consumers? And more broadly, are there any general characterizations of a merger or an industry that you think can help us to predict whether a merger will in fact benefit consumers?
Well, again, I would indicate that this is an area that defies easy generalizations. Markets differ, and clearly the merger guidelines do look at the possibility of efficiencies from a merger when they are demonstrable as a factor to be taken into account, along with the impact of the merger on market power. And I believe that what the antitrust authorities have done appropriately is to look at the specifics of individual cases to try to understand the markets in question and what the nature of the efficiencies are and whether they would be substantial enough and likely enough to be passed on to give them substantial weight in deciding on a merger. I think that's appropriate.
Well, some have suggested that the creation of corporate giants, which we have seen in some of these recent mergers, in effect creates firms that are, quote, too big to fail, unquote. In other words, that these firms are so big and represent such a high share of their particular industry that should they falter, then the government would have to bail them out at a significant cost to the taxpayer. What's your view of that particular suggestion?
Well, certainly in the industry that, in a sense, I'm most familiar with, which is banking, having previously served as a Fed governor and looked at bank mergers, safety and soundness was appropriately taken into account, as it should be, as a factor in evaluating mergers along with their competitive effect. Certainly there, a case where we have an explicit safety net, I believe that the safety and soundness of the firm is an important consideration to take into account.
Okay, do you believe that the mergers of the 1970s and the 1980s have had anything to do with the lower inflation rates that we enjoy today? That's kind of a out of the ballpark question.
With the lower inflation rates, I think as a first approximation, I would say no. The mergers from the 1980s, there is now a substantial literature that has tried to evaluate whether or not they've promoted efficiency. There certainly is some research that suggests that many of the mergers undertaken in the 1980s, some of which offset the concentration, the increases across industries, may have improved efficiency, and I think that if that's true, that's a factor that's worked to improve economic performance. But as far as inflation is concerned, I would not regard the merger wave as a major factor influencing inflation.
Okay, thank you. Senator DeWine.
Thank you very much. Doctor, you've stated in your prepared testimony that merger activity has certainly increased substantially in the past few years. Excuse me, but it's not clear that the level of merger activity is unprecedented. And you've gone on to describe the different merger waves. Is there anything about this merger wave that we're in now that is unusual, that's different from other merger waves? And is there anything in particular that we should be on the lookout for, any signs of concern?
Well, the current merger wave is somewhat different from previous merger waves. We've seen previous merger waves that were clearly horizontal, where horizontal mergers predominated. That's what we saw at the turn of the century. And clearly, increases in market power with adverse impacts on consumers was a concern. The merger wave in the 60s, in contrast, was really a conglomerate, largely a conglomerate, not horizontal mergers. It's difficult to characterize the current merger wave. It seems to be somewhat different in the extent that many of the mergers appear to be looking for synergy in firms in related product areas, but they're not purely horizontal. In some cases, we're seeing market extension mergers. In some instances, in important industries, the merger wave that we're seeing, I believe, responds to deregulation. Banking is a good example, and telecom is a good example. So there are some different characteristics to the current merger wave. And again, going back to the idea that it's hard to generalize, that what we need to do is to look carefully at the specifics. I believe that that's what really is necessary here, is to look at the specifics. I guess once upon a time, antitrust policy had the philosophy that big is bad. That seems clearly to be a bad philosophy, that big is not per se bad, that's not an appropriate philosophy. On the other hand, one wouldn't want to go to the other extreme, it seems to me, to say that there's no cause for concern, that anything should go, and something more balanced and in the middle that says, let's look at the specifics of particular mergers in particular markets, I believe is what's appropriate in this case.
Well, let's look. Let me ask you then, Doctor. Thank you for the answer. Let me ask you to get more specific and look at a few of the industries where we've seen these mergers. Are there any particular industries where you see any kind of where you're alarmed by what is going on?
Again, I'd say one needs to be an expert and to have done a detailed analysis on particular industries, and I'm not an expert on most of these industries. I think that what's appropriate is really to look in detail at likely impacts in particular industries.
I want to mention it.
Thank you. Thank you, Mr. Chairman.
Thank you. Well, Dr. Yellen, we appreciate you taking time from your busy duties to come up, and we appreciate the service you're giving the government as well. And thanks for your testimony here today.
Thank you for having me.
Thank you. Well, on our third panel, we have the two officials from the federal government responsible for antitrust enforcement. Joel L. Klein, Assistant Attorney General for the Antitrust Division at the Department of Justice, and Robert Potofsky, Chairman of the Federal Trade Commission. We appreciate both of you, and I'm grateful that both of you would take time to be with us today, and we look forward to hearing your testimony. I think we'll begin with you, Mr. Klein, and then we'll go to you, Mr. Potofsky. Now, we'll put all statements in the record as though fully delivered. And should we go? Which one?
I got some charts. Oh, you have some charts.
You would prefer? Go ahead, Mr. Potofsky. We'd be happy to take you first.
Thank you, Mr. Chairman. It's, of course, a great pleasure for me to have an opportunity to testify on behalf of the FTC on the issues of the current merger wave. If one thing is clear on the basis of what we've heard this morning, there's common ground that there is a remarkable merger wave going on, probably the greatest since the end of the 19th century. Twice as many merger filings that we review compared to 5 years ago. 3 times as much market value scooped up in transactions as in 1989. I took a look this morning to see how many billion-dollar mergers there were in the recent past. In 1982, there were 6 billion-dollar mergers. In 1986, at the height of the 80s merger wave, there were 36. These days, it's hard to get through a day reading the newspaper without at least one multi-billion-dollar merger being announced. What I would like to do this morning is address 3 questions. Why is this happening? Does this merger wave bode ill for the U.S. economy, for U.S. workers, for U.S. consumers? And then third, is contemporary American antitrust capable of dealing with this merger wave in the context of competition in an increasingly high-tech, increasingly global marketplace? Why is it happening? Let me start with an observation. To me, the mergers that we see these days make more sense than many of the mergers that we saw during the frenzied merger period of the 1980s. In those days, in my opinion, too many of those mergers were initiated by quick buck artists who were trying to make a killing on the stock market. Leveraged buyouts, hostile takeovers, junk bond financing devices, all suggested to me that what corporate managers were after, not always, but often, was not efficiencies, but really an opportunity to enrich corporate traders. I don't see it quite that way today. Most of the mergers we see seem to be a response to legitimate economic concerns. Globalization has been discussed already this morning, technology changes, deregulation, corporate downsizing. On the other hand, there are mergers that occur constantly which are not in response to any of these things, but really designed to increase the market power of the merging firms in order to dominate markets. Mergers have been called the royal road to monopoly, eliminate pesky, troublesome competitors, increase concentration in order to raise price. But let me put all that in perspective. Of every 100 mergers that we look at, we pass 14% without even examining very closely the facts of the transaction. They raise no problems at all. We thoroughly investigate and analyze 4.5% of the mergers. That's the Hart-Scott-Rodino second request. And in the end, we only challenge 2% of the mergers that we see, of the 4,000 or more that we'll see this year. Now, that's a lot more than the number of mergers challenged, say, 10 or 15 years ago, but still, it seems to me the important story is the 98% that go through because they either help consumers, invigorate the competitive process, or more often are neutral than the 2% that we challenge. Is this merger wave bad for the country? Well, let me break that down. On an economy-wide basis, I think that there is a little problem there. I agree with Chairman Greenspan that there's as much entry as there is departure through merger activity. Are there specific sectors we ought to look at carefully? Well, yes, absolutely, and we try to do that. Defense is one area, pharmaceuticals, some areas of retailing and wholesaling. But really, the issue is case-specific. The case that we brought that got most attention last year was Office Depot Staples merger. We challenged it successfully in court. We made the argument that the judge agreed with, that had it gone through, it would have cost consumers over $1 billion over 5 years. Prices of office supplies would have gone up 13% in many cities. That's the anti-competitive effect that we're concerned about. Finally, is antitrust, that 19th century philosophy that has served the country well, is it up to the job of deciding cases at the end of the 20th century? We held some hearings last year to address that question, and most of the witnesses seem to think that we're roughly in the right place. The core of antitrust, challenges to monopoly and to price fixing, was sensible. I heard Chairman Greenspan say that merger analysis would be better if we didn't make projections, if we let the merger go through, and if we then challenge the merger thereafter. With all respect, I don't agree with that. First of all, it would be a radical departure from what Congress told us to do in 1950 and what the courts have consistently told us to do. The problem is that if you challenge the merger before it happens, it's not very expensive to remedy it. After the merger, after the assets are scrambled, the employees have been fired, the management has gone elsewhere, the factories have been sold for junk in some other country, then putting the company back in business is enormously expensive. Congress recognized that and therefore said the statute reads where the result may be to lessen competition, not where the result is to lessen competition. Is antitrust up to the job? Well, let me mention 3 things that we've addressed. 1, numbers are not dispositive in our mind. That's a development that we've embraced that's been going on for about 30 years. Even if you had 2 parties to a merger with 25% each, that would be the beginning, not the end of analysis for us. We would then go much further and look at whether there's an anti-competitive effect. The best example of that is the Boeing case, which we did not challenge last year. Boeing had 60% of the market. McDonnell Douglas had 5%. But we went further, interviewed all possible acquirers of airframes, and found that hardly anybody thought that Douglas was an effective competitive force. So that removing Douglas by merger was not anti-competitive. Second, I believe, and we've clarified this point, that especially in a global economy, efficiencies are essential. And therefore, when a party comes in a close case and says, we're going to show you that this merger is efficient, we now accept that kind of evidence. We don't resist it. That's really quite a departure over the last 10 years. Finally, our hearing suggested that we should be more concerned, far more concerned, about mergers at the innovation stage of market activity. That in the areas of the economy that we care about most, the competitive fight is settled at the R&D stage, and with first mover advantages, it's almost impossible for anyone to catch up. The best example was the proposed merger between Ciba-Geigy and Sandoz about 2 years ago. They were both miles ahead of everybody else in gene therapy, designed to address problems like cancer, AIDS, hemophilia. We challenged that merger and made the parties spin off their gene therapy capacity to another party because we felt that even though products will not get to the market for 5 years, we would find that it was too late to do anything about it if we allowed the innovation merger to go through. Finally, let me just say one word about the point that's been made by several senators this morning, and that is the effect on workers. I think one would have to be blind not to see that with respect to a lot of these mergers, senior management makes out very well and a lot of workers lose their job. One possibility, which I do not agree with, would be to block mergers in order to preserve jobs. Sometimes the very efficiency of the merger is downsizing, make the company leaner and tougher, especially in global competition. On the other hand, we can't forget the workers who pay a price here, and I agree with the suggestion that there should be more thought given to retraining, to transition, to subsidies. I heard the proposal about not taxing severance pay. There are many possibilities to help the workers and not allow them to pay the price for what I think is a good thing, and that is efficiency-oriented mergers. Thank you very much.
Thank you. That was very interesting. Mr. Klein.
Thank you,
Good to have you
Mr.
here.
Chairman. If I might, I'd just like to put up one or two charts to illustrate where we are. First chart shows the number of hard stock pre-merger files, which I think is one indication of what we are seeing in our economy. Essentially, all significant mergers are likely to be reported to us in the Federal Trade Commission. And if you look at this,
Joel, I wonder if you could maybe hold up there's a mic right in front. Help him out here. And why don't you use your mic so that
use this.
people watching on television might.
All right. What you see here, Mr. Chairman, is really over this decade a very steady and dramatic rise in the number of mergers, 20, 25, 30% per year in our economy, to the point now where in this fiscal year we are looking at a number close to 4,500 mergers. And if you look at 1990 or 1991, we were looking at 1,300. So we're talking really about a 3.5-fold increase in filings. And that number, Mr. Chairman, doesn't tell the complete story. The real story is in the second chart. This chart talks about the value of merger activity. That is not just the number, but the size. And here, this graph goes up rapidly, asymptotically, towards some very huge numbers. Indeed, perhaps the most profound statistic here is that in the last fiscal year, we were just under $1 trillion in U.S. merger activity. This fiscal year, we're going to double that number. And again, that's, if you look at that, that is a significant, and I submit, dramatic increase. And as Chairman Potofsky said, if I could have the chart with the major mergers. It's not just that $1 billion merger is not a big deal anymore. All of these are very recent. These are the last 6 months, essentially, and we never saw anything like it before. Travelers Citicorp, $70.4 billion. Nations Bank, Bank America, $60.5 billion. Right down the chart to Bank One, First Chicago, $26.6 billion. So the point, Mr. Chairman, is that what is going on is very significant to the economy. Indeed, when I took over this job about a year and a half ago, I thought we were in the middle of the merger wave, but I didn't realize that the wave was actually a very sort of soft one compared to what we're now looking at. Now, from our point of view, like the Federal Trade Commission, we see this as a challenge for antitrust enforcement. It's an important challenge for our economy, our workers, and for our consumers. But I want to make clear, we don't necessarily see this as a matter for concern. Mergers, even very large mergers, can be good for our economy and our consumers, or they can be bad. And our job, along with our colleagues at the Federal Trade Commission, is to make sure that the good ones, the ones that help the nation, go through, and that the bad ones are stopped. The key to what we do is a very simple key. It's one really that was enshrined in the Sherman Act, re-embodied in a merger-specific form in the Clayton Act, and is at the core of everything that's good about and correct about antitrust enforcement, and that is we focus on competition, not on size. Our economy, Mr. Chairman, is the most powerful economy in the world today. And in no small measure, that is because it is the most competitive economy in the world today. And that is because markets, in large respect, work. And we have a great deal of respect for markets. But we reject categorically the notion that markets will always self-correct and that we should simply sit back and watch as all sorts and all kinds of mergers, mergers to monopoly, mergers to near monopoly, go forward. Surely, most mergers, even in the current merger wave, are going to be fine. And yes, I agree, the government needs to be careful, and government officials need to approach this with a great deal of humility. But in the end, Congress charged us, properly in my view, with the responsibility of separating the market power mergers from the efficient mergers, and I think we should conduct that responsibility cautiously but sensibly. Indeed, I think we're paying a price in this country, Mr. Chairman, because of a failure with respect to some airline mergers in the 80s, and most recently, quite troubling to us, the Union Pacific, Southern Pacific merger in the rails, one that we opposed and the Surface Transportation Board approved, and the consequences of that are still being borne on many, many good businesses, good farmers, good people in the South and the Southwest. Let me just say a word without repeating what Chairman Potofsky said about the way we do our work. First and foremost, we look for solutions. We don't want to stop mergers that can be helpful in whole or in part. And if we can excise the anti-competitive part and protect the competitive part, we do so. But one of the things that's important is we're not a private litigant. We won't settle for 50 cents on a dollar. And so one thing that I think is important, in the past year at the Antitrust Division, we have brought 5 merger cases to federal court. That is the most in any one-year period since the inception, I believe, of the Hart-Scott-Rodino process. Among those are some very major mergers critical to our country, including the Lockheed Martin-Northrop Grumman merger, which involves very, very high concentrations in the defense industry, looking at key technologies that would go from a 3-to-2 or a 2-to-1 situation. The Prime Star merger involving one of the real opportunities for an alternative to the cable monopoly being bought up by the cable companies who have no real incentive to compete against themselves. And also some very small mergers. A radio merger involving a local market, a hospital merger as well. In all of these cases, what we were concerned about is anti-competitive impacts that would harm consumers and ultimately undermine economic efficiency. The other thing that's important is by bringing these cases, we send a signal to the market as well, that what we are looking at is the difference between efficiency and market power. And the real work of antitrust enforcement, unknown to most, silent in fact, But the most effective work of antitrust enforcement in the United States is being done by the fine men and women in the antitrust bar who counsel clients on what is likely to succeed and what is not. And while their recommendations are surely not always followed, in the many instances that they are, we are not seeing mergers come forward that would clearly violate the antitrust laws. So I think the process is working well. I think we have a large challenge ahead of us. I agree with Chairman Potofsky that there are issues regarding workers, there are equity issues that need to be considered, but not in the context of enforcement of the antitrust laws. Thank you very much, Mr. Chairman.
Well, my thanks to both of you. You have very important jobs in this government, and frankly, I know both of you are doing good work. Let me just ask both of you this question. Many believe that we're presently at a critical juncture in our economy. On the one hand, the so-called digital revolution is promising a fundamental restructuring of the way we do business, and it appears that the outcome of many of today's market battles are likely to set the foundation for tomorrow's economy. At the same time, we're seeing an unprecedented wave of mergers and consolidations, which both of you have described, and that wave in and of itself is fundamentally reshaping many of our most important industries. My view is that the coincidence of these trends calls for an unusually perceptive, insightful, and consistent antitrust policy. However, corporate America seems to be troubled by the high level of uncertainty regarding whether a particular merger will or will not pass antitrust muster. Now, what can both of you do to ensure that you are implementing a consistent merger policy and at the same time give greater clarity to what that policy you're administering really is?
I think that's a fair challenge to us, since most merger review and deterrence takes place at the private level, as Attorney General Klein just said. We try our best. We probably have the most extensive set of guidelines indicating where the line is with respect to mergers than any other sector of antitrust analysis. And we've been changing the guidelines. They were issued in 82, 84, 1990, again revised last year. We're trying to be as clear as we can, but merger analysis is very complicated, as you point out. One problem in this area is an interesting one, and that is that the Supreme Court hasn't heard a merger case in something like 25 years. And even at the lower court level, we too have more cases in litigation than at any time in the last 10 or 15 years. But few cases actually go to a verdict by a judge in a district court, and even fewer go to courts of appeals. So I'm sorry to say that the courts, to some extent, have been dealt out of the game of offering advice as to where the line is for legal and illegal mergers. We therefore turn more aggressively to guidelines, and we do our best to indicate what the proper rule is.
I see. Joel?
I would just add briefly, Mr. Chairman, I suspect that in the overwhelming, and I mean somewhere around 99% of the mergers, people have relative confidence as to how the agencies will act, or if there is a problem, that it is, if you will, a fixable problem. There are a few cases where the merger doesn't go through, and even though people say that this is a surprise, sometimes when we do our work under the Hart-Scott Challenge, you'll see memos or notes in there saying, well, this could run into a little troubled waters with the antitrust authorities. So I think there is a fairly good sense. I agree in the end with Chairman Potofsky. There is going to be a couple of 3 cases in the course of a year which are really the tough, hard ones, the ones that businesses say, let's be aggressive and see if we can get through, the ones that our analysis, which is very thorough and fact-based, it's not a philosophical inquiry. We go out and get documents, literally millions and millions of pages of documents in these cases. Sometimes it takes us 6 months, 8 months to do the thorough job we need to do. And in the end, those are tough, hard judgments. When we have the measure of confidence that we think we need, we go ahead and proceed.
Well, in developing and implementing antitrust policy that is up to the task of today's rapidly evolving economy and global marketplace, I believe that it's important not just that enforcement policy be revisited and recalibrated, but that the same is done for the antitrust laws themselves. Let me ask at a general level of whether you think our antitrust laws are up to date with regard to our current economic trends, and are there any areas which you think at least should be revisited by the Congress?
I think in general our antitrust laws have served us very well over the course of their 100+ years in existence, and will continue to serve us well because they contain a core kernel of truth that is as important today as it was in 1890 when the Sherman Act was passed, and that is competition is the engine that drives this economy. And Americans know it. They know it instinctively. Nobody wants only one airline or only one accounting firm or only one gas station in their town. People know the benefits of competition, and the antitrust laws have wisely been able to take that core concern and adapt it to today's technology. Now, what that will mean, as Chairman Potofsky said, is you will look at innovation markets today in a way perhaps that they weren't looked at 30, 40 years ago, because innovation in our current globalized high-tech economy may play a different kind of role. You will look at potential competition somewhat differently now that we're going through massive deregulation. But I think the tools that are in the toolbox are the right ones, and I would also say that we certainly believe the courts ought to be re-engaged, and I think that efforts have been made to re-engage the federal courts, because I think the genius of antitrust has been its common law tradition in the federal courts, a tradition you're quite familiar with, Mr. Chairman, and I think that regulations that attempt to micromanage through legislation, that attempt to micromanage some of these competitive problems, could in the end do more harm than good.
Thank you. We'll turn to Senator Torricelli and then our chairman of the subcommittee on antitrust, Senator DeWine.
Thank you, Mr. Chairman, very much. Mr. Klein, it occurs to me that with the great variety of antitrust cases in which the Department is now pursuing, there is one that affects potentially more Americans than all the remainder combined. And that is with the recent mergers and acquisitions of the nation's largest banks. More than 50% of all the credit cards of Visa and MasterCard are now going to be held by only 4 institutions. As you know, on previous occasions in these hearings, I have raised this issue with you that at some point we have to deal with one of the greatest anti-competitive practices in the American economy. And that is that as a matter of contract, Visa and MasterCard are requiring these banks not to allow competitive credit cards to be issued. On its face, this is anti-competitive and it appears to me to be blatantly illegal. I understand, I genuinely understand, that your office is now fighting on more fronts than the U.S. Army at the worst of World War II. I know the ferocity with which these litigants are confronting you in so many different arenas. But this problem is not going away. And more than the consolidation in the defense industry, even potentially in the airline industry, and certainly in the high technology industry, to Americans who may be paying too high interest rates and getting insufficient service, this is impacting them more directly than in any other field in the economy. This must be addressed. We cannot allow 2 credit card companies to tell the nation's largest banks that they cannot deal with anybody else. Now, it is not simply that I'm saying this because I believe it's unfair to other corporations who issue credit cards. It is the banks themselves who, at the moment, are being silenced because they fear retribution, but are also victims of this, who would like to have competing products. Now, I'm not asking you to address this at all on the merits, but simply in fairness, and as you know, Mr. Klein, I yield to no one in being a fan and an advocate of you and your department, but on previous occasions, the committee has been assured that we would deal with this in 2 months, 3 months, and in 6 months, and for understandable reasons with other cases it's been delayed. But I would like some assurance that consumers are going to at least know that this question has been addressed soon.
Well, I will give you my absolute assurance to that effect. And I want to make clear this is a matter that I have been personally involved in extensively and continue to be so, that whatever other litigation or other issues that are before us, this has always been an important matter for me. There are important issues here, Senator Torricelli, without commenting on the merits. When antitrust enforcement gets involved in issues that are so important and so profound for America's economy, I think that we want to make sure that we get it right, and that is what we are in the process of doing. That is not a four-corner offense approach to enforcement. That is, it seems to me, the prudent, sensible one. There are, as has been reported in this case, there is the issue that you raise about bank exclusion. There also is the issue about duality and the relationship between MasterCard and Visa, and the intersection of those issues are both complicated and important. But make no mistake about it, this is not a matter that has receded into the twilight or that is not of principal concern.
That's reassuring to me, and I just want to underscore that at a time when interest rates are at historic lows, the fact that most Americans may be paying 15, 16, 18% and more on their credit cards is the greatest example I know that competitive factors are not working in this economy. And banks which would like to go to their customers with a competing product in a credit card are being restrained from doing so. And I know of no greater concentration and power than when you have 50% of all the credit cards being issued in this country are only by 4 institutions. And even those institutions do not, by contract, have the power to bring in competing product. There is something fundamentally wrong. And this doesn't impact a few Americans. It impacts not only most, but the great majority of Americans. So I hope that at some time in the near certain future, we can have the issue either dealt with or disposed of, so we know where we are. Second, I'd like to deal with, in the telecommunications field, by any measure, the congressional intent to deal with competition in telecommunications, if it has not failed, it is at least frustrated. Our vision of providing competition with long-distance carriers and the regional carriers has simply not succeeded. The nation is now left with 4 regional bells. There's no reason to believe there will not be further consolidation. The great long-distance carriers that our hope would enter into the local phone business have clearly also failed. In 1997, Reed Hundt made the statement that it was unthinkable that AT&T would itself be able to acquire or merge with a regional bell. It appears to me the world has changed remarkably. AT&T now has less than 1% of the local phone business. We've now gone through mergers of regional bells themselves. This is less than a question because I suspect I'm not going to get you to address the merits, particularly of an individual case, nor do I think that you should, but more in the nature of a statement. If we are going to have real competition now, it may be under a very different scheme. It may be by allowing, even inviting, long-distance carriers into the acquisition or mergers with regional bells to provide some vertical integration to provide real competition. Otherwise, we are simply recreating the old monopolies. We may end up with 1, 2, 3 regional operating companies and several long-distance companies, and the lines may rarely ever be crossed. And if they're crossed, it will be from the regional bells into the long-distance business and not the other way, which economically is unsustainable. Therefore, my hope is those lines can be crossed. What was good in Reed Hundt's time may not be good anymore. This is a very fluid situation. I'm certainly not precluding you from addressing it, but I suspect you didn't want to. But
I think we can leave it right where it is.
okay. Third, on the issue of Microsoft, let me just say this. As you know, I've admired the Department's aggressiveness in dealing with antitrust. I simply hope this. Sometimes in the battles of titans, fair and reasonable accommodations are not reached, less for matters of public policy than the pride and authorship of those who enter the encounter. Microsoft and its innovation and its marketing is an important part of the growing efficiency of the American economy. It is a great American corporation. If reasonable minds can meet in accommodation in the coming months, I have enough confidence in your integrity, your administration of this department, that I hope things that have been said, the visibility of the case is put aside and reasonable minds can meet. In a fluid economy of innovation like our own, the withholding of products, the inefficiencies of this confrontation, I hope can be overcome in order to reach accommodations. And that you will all be tested on that in coming months as you get closer and closer to a trial date. Finally, if I could, in one that is not in your own area but in the Federal Trade Commission's, Mr. Pitofsky, if I could simply lend a commentary again on the issue of Intel. As one who believes in antitrust law and the activities of the last year, this is one case that does concern me, in which I feel, as I suggested earlier in this hearing, the federal government could be moving on an antitrust case when, ironically, the market is going to be looking in whether or not Intel is properly positioning itself for the rapid changes of technology in the economy. Where there is dominance at the moment, a company may ironically be exposed because the product line in which it dominates may not represent the future. As I suggested earlier, the federal government has been down this road before with IBM, where a case becomes moot for reasons that should have been clearer at the outset. My suggestion to you simply is tread softly in looking at this case on its merits, at least on the surface. It appears to me that there may be a market answer to what is at the moment being presented as a legal case. I have no expectation of you addressing that either, but I've enjoyed having two witnesses that I can speak to who have almost no ability to respond to anything that I say.
Well, we'll just leave it at that, Senator.
But, Mr. Chairman, again, this has been very useful for the committee.
Sure.
And I appreciate very much having read the testimony. I was not here when they both presented it, but I did read it. And I'm grateful to each of them and to you, Mr. Chairman, for giving us this opportunity.
Thank you, Senator Torricelli. We'll turn to Senator DeWine.
Thank you, Mr. Chairman. Last week, you signed an addendum to the so-called positive comedy agreement with the European Union. I wonder if you could tell us how the FTC and Department of Justice will handle their review of mergers that principally affect the United States but have some international impact. The timelines for review of mergers are different in the U.S. and Europe. I guess the concern is that there might be situations where the European Union could drive decision-making in the United States on an American merger simply because their laws and regulations force decisions to be made on a tighter timeline. How much of that is a problem? What do we, quite bluntly, what do we do to ensure that the United States remains in control of situations that very directly impact us and that are, in fact, primarily American mergers?
I think I want to thank you for asking that question, Senator DeWine, because I think this is a very important question and there's been some confusion. First and foremost, I want to assure you, and I am sure Chairman Pitofsky would say the exact same thing, on mergers that are before each of our agencies, we are in control, in charge, and make the competitive decision, and we'll stand by each and every one that we make, regardless of whether the Europeans or anyone else is going to review it. Now, given the interests of the parties, it is certainly worthwhile for us to be able to coordinate and cooperate in terms of working with the Europeans or the Canadians or anybody else. But when a merger is one before our agency. We make the decision. Now, there have been some actual reports in the press about the WorldCom MCI merger, and that somehow we had deferred to the Europeans. And I want the record to be absolutely clear. That is incorrect. We have done our own analysis. We have come to our own conclusions, and we will enforce those conclusions as we see appropriate. We will, of course, discuss that with the Europeans so that if there are potential disagreements, as there has been on some occasion, we can seek to understand the nature of the disagreement, and if it's something that can, through education, be eliminated, that's all to the good. But these decisions are being made on the merits by the Department of Justice. The parties to transactions, Senator DeWine, are often willing to play one agency off against another and to try to create the appearance either of friction and or control. In my experience, those are short-lived stories and don't really tell what's going on at the agency itself.
I agree with all that Joel has said. I think positive comedy is a good idea. I don't expect it to be invoked very often, but I think there are cases where it's better to have a foreign country review behavior in the first instance under their law rather than our reach out across continents to enforce our law. But I do not expect, indeed there is no intent, that positive comedy would apply to mergers. Mergers are true, there's time deadlines, there's special circumstances in those situations, and I would not expect to ever defer to another country on a merger enforcement decision. I think that must remain in the control of the two agencies.
Well, I appreciate your answers. As I think you both know, this is an area that I'm concerned about, and you know, we intend in the subcommittee, antitrust subcommittee, to continue to monitor. It is, I think, of great concern. Excuse me. Let me ask you a question that I asked of our previous witnesses, and that is to put the current wave of mergers in some sort of historical perspective.
Well, I think there have been 5 merger waves. I think this one probably ranks up there at the very top with the merger wave at the end of the Industrial Revolution, at the end of the 19th century. I think it's a consequence primarily of an extremely dynamic economy. It's a vibrant, prosperous economy. It's changing rapidly, especially in the high-tech sector and in the area of globalization. And I think in general, people should not lie awake worrying about these many mergers that are going through. I think for the most part they're constructive. It's those few mergers which are designed and have the effect of taking money out of consumers' pockets and transferring it to the owners of the corporation. Those few that we have to be alert to, and we have to continue to have the resources aggressively to challenge those mergers. The general trend does not seem to me to threaten the American economy in any way.
Mr. Klein?
Yeah, I think that I generally agree with those comments. I think one thing that really is quite interesting right now is that a large portion of the big mergers are really reactions to the deregulation and continuing deregulation of the American economy, whether it's in telephony, whether it is with respect to banking. There's still issues in the airline industry where you have lots of international regulation. So I think markets that were essentially static have now become dynamic, and that's going to lead to a great deal of activity, and obviously globalization is going to continue that trend. But it seems to me, other than the fact that all of these mergers have unique historical consequences, and certainly the size of what we're seeing now is quite dramatic, that there's no great cause for concern or overreaction with respect to it.
Thank you very much. Thank you, Mr. Chairman.
Well, thank you, Senator. But let me just ask, since the Senator raised the European Commission, maybe I could just ask one or two questions about that, whether or not U.S. merger policy actually accounts for global competition. One consequence of the global economy is that more and more mergers are being subject to review by foreign antitrust agencies, and most notably among them is the European Commission. I was quite interested to see that the United States has signed an addendum to the existing antitrust cooperation agreement with the European Union. And as far as I know, there was virtually no discussion with Congress prior to the signing of this agreement. Could you explain why or why not?
Well, I do think there was some discussion. Probably in retrospect not enough discussion, and I take responsibility for that. This was not a merger-based document, and that's where I think some of the confusion. Had this involved any deferral with respect to mergers, I can assure you there would have been far more extensive discussion, Mr. Chairman. The document, I think, is...
Well, no, what I'd ask is, since I understand that that the agreement with the EC does not apply to mergers, why not?
The reason was because the problem in mergers is different than the problem that this addendum addressed. The addendum addressed anti-competitive behavior predominantly in the other country's market. It was a market access problem, whereas mergers, at least when we look at them or when the Federal Trade Commission looks at them, are mergers that affect anti-competitive behavior in our own economy. And when it affects anti-competitive behavior in our own economy, we do not defer. We do our own work. When it affects, for example, access by computer reservation systems in Europe, where the European computer reservation system was locking up the market and American companies were not able to gain market access, that was a case we thought should be referred to the Europeans. First, because they could get the evidence. Second, because if there was a problem, they had the power to remedy it. And third, because as a matter of international comity, it seemed more prudent for us to stay our hand and give them a first shot. So that's the way that agreement works. With respect to mergers, we did not propose, and I didn't understand that there was any congressional interest in some sort of positive comity type arrangement.
Okay, Mr. Klein, I know that you have established an International Competitiveness Advisory Committee. I take it to make various recommendations to you regarding policy for multinational mergers, investigating and prosecuting international cartels and antitrust violations, and regarding the relationship between antitrust and trade policy. And I certainly endorse your examination of these policy areas, but again would remind you that antitrust policy is not entirely a matter of enforcement discretion, but is ultimately grounded in the antitrust statutes. Now, what are your expectations for the timing of the Advisory Committee's recommendations, and what discussions do you plan to have with Congress regarding the formulation or the implementation of these various recommendations?
The advisory committee, which is, as you know, is chaired by Jim Rill, who was the Assistant Attorney General during President Bush's tenure, and Paula Stern, who was the head of the trade agency during the President Carter's tenure, is just begun its formal work. It has, as part of its work plan, extensive consultations with Congress. It is anticipating issuing a report somewhere in probably October of 1999, and both in terms of early consultation and then further consultation before any report were to issue. I will ensure that that does occur. That is our intention, and we will see that it's carried out.
Well, thank you. I want to thank both of you for being here. I know it's an inconvenience to you with the busy schedules and the busy duties that you have, but I might just mention with regard to Microsoft, I know that you're moving ahead with that as fast as you can, and it seems to be breaking. More and more news and more information seems to be breaking almost on a daily basis. We probably will have another hearing before the end of this summer that will I think be very interesting to everybody, and that may be something that you will want to watch in the overall scope of things, because I think it's a much more complicated issue than just the browser wars, and a lot of people don't seem to understand that. And you and I both know that when you have conduct decrees, in essence, that's what I'd use those terms, that they're very easy to get around, and that some of the anti-competitive practices that are alleged are very serious. So we'll we'll be interested as your case proceeds in watching it and seeing what happens, and we're certainly interested in the Intel case as well. I don't know as much about that as I do Microsoft, and what little I do know, it certainly makes that interesting to me. I might mention that both of these companies are great American companies, and they earn their dominance. It seems to me, that comes under attack by some, but so is Netscape, a great American company. So too is Oracle. So too is Lotus, and many other corporations. And the question is whether the questions seem to relate to whether there is anti-competitive or predatory or other types of violative conduct. And we'll be interested in watching both cases, and all I can say is that I'm confident that the country is well served by the two of you, and we want to be supportive of you as much as we can. And I just personally want to thank you both for being here today. With that, we'll just recess until further notice.
Thank you, Mr. Chairman.